Gentlemen, we're going to excuse you for a few minutes. I think we're getting a little long for a sidebar, and so we want to get this on the record. And it's one of those recesses we talked about in the preliminary instruction. So it should be just a few minutes, and we'll have you come back in. Okay? Okay, may be seated.
Thank you.
All right, may I just introduce the, hang on just a second here. Okay, we just had a sidebar. There's an objection raised by Mr. Hahn to the question related to this previous incident where he had gone to the hospital following a motor vehicle accident involving Ms. McCandless. And there's discussion about this extrinsic evidence. I don't know that we've addressed this issue entirely, but the court has previously indicated that it would not allow this extrinsic evidence from that incident for purposes of corroborating what had occurred with respect to Ms. McCandless using her given name as opposed to her chosen name. In any event, I want to give counsel an opportunity to make a record on this issue because we were getting a little long for a sidebar, and frankly, I don't think I could remember all of it. So, first of all, Mr. Hahn, why don't you just state your objection?
There's an open motion that hasn't been fully decided. I'm looking for it now, but I don't have it in front of me. It was a motion to preclude the defense from introducing extrinsic evidence, or really the motion was against introducing evidence of the prior car accidents altogether. Secondarily, if the court was going to allow it in some limited fashion, to allow it only through the testimony of the defendant if she chooses to testify.
So
That was the basis of the objection.
So my recollection is a little bit different than the state's.
Okay.
Not saying the state's not saying it.
That's why it's important to do this while it's fresh in your mind.
Okay.
I'm sorry, recollection of the sidebar or of the procedural?
No, of what happened, the motion. So my recollection is that the court did state that we could elicit this evidence because it is part of the basis of our expert's opinions. First of all, Judge, I'm a little uncomfortable arguing this evidence in front of the witness. Can he be excused?
Yes, sir, if you would just step down and go into the hallway and someone will come and get you when we're ready to have you come back, okay?
Roger.
Yeah.
Okay.
Okay, thank you.
The record will reflect that
Yeah. I just
Mr. Mangle
realized.
has left the courtroom.
Thank you. I just realized really a violation of the sequestration to hear him to hear what other witnesses are anticipated to
Thank you.
testify
Appreciate
about. So, just to lay out the factual basis. Ezra McCandless had an accident with a horse that was very traumatic for her when she was 16. The only reason that has anything to do with anything is because at a later time, a few years later, once she already knew Mr. Mangle, she had a second car accident. She drove into a ditch. She went into kind of a dissociative state. She was asking about the horse and if the horse was okay, and she was calling herself the name Monica Carlin. Mr. Mangle is aware of that. The court ruled that we could not bring in a nurse as a witness about the actual car accident, but the court ruled that our expert, Dr. Hopper, can testify that that trauma is part of the basis of his opinion. And the court also clearly said that Ms. McCandless herself can testify. Oh, I'm sorry. Mr. Nelson is saying actually we didn't get a ruling on the nurse. I stand corrected. We said we would take it up after Ms. McCandless testified. So I stand corrected by Mr. Nelson. He has a better recollection than I do. So actually what Mr. Hahn says is correct. It wasn't fully ruled on. But it's appropriate now because she was in this accident, and Mr. Mangle went to the hospital and observed her in this dissociative state, observed that she was asking about the horse, observed she used her prior name. There has been an inference that she lied about her name through a prosecution witness, the EMT, and I'm sorry, I cannot recall the witness's name right this minute.
Joseph Wayne.
Thank you. That she gave a false name. And certainly, the state has met with and prepared their witnesses in advance and should have been able to advise him that that was not the case. But regardless, that didn't happen, and he said she gave a false name, and as a result, the defense had to show that it wasn't actually a false name, but a given name. And I think there's an impression, especially with Mr. Mangle, giving us gratuitously, not being asked, that she's a liar or that she lies to him. This is something, and the other thing that happened is in the opening statements of the parties, two things occurred. On the defense side, the defense told the jury that Ezra McCandless acted in self-defense after Alex Woodworth was the first aggressor. The court has allowed, consistent with case law, the state to bring in evidence that would not ordinarily be admissible to rebut that by showing that Alex Woodworth had a reputation for being peaceful. That's been elicited, and I believe that the state has other witnesses that it is going to elicit in its case in chief before Ms. McCandless took the stand. Because when somebody says something in an opening statement, evidence can be brought out to rebut that. The state argued in its opening statement that Ms. McCandless is a liar and that she's lying about everything that happened. And the state, through testimony it elicited from Deputy Shields, talked about her crying without tears. There was some inference that she was trying to be upset, were the exact words that Mr. Shields stated.
Okay, but counsel, here's the question.
Wait, what I'm arguing is that the state has opened the door. This is not extrinsic evidence on a collateral matter. This is not collateral. This is central to this trial, that she suffered this trauma and has this post-traumatic stress disorder / dissociative state, that is not collateral, that is central to the trial, and that there's been an inference here that she's making these things up. And this shows that this is not being made up. This has actually happened, and this is a part of who she is. That it is not, in fact, some type of fiction, and the state has tried to do that. And the state will cross-examine her. It is not character evidence. I think, as we talked about previously, it's an involuntary reaction that Ms. McCandless had to previous trauma, and I am attempting to elicit that. It is not propensity evidence. It shows that she has this involuntary reaction. We have an expert's opinion based on it. The state is attempting to say that she's a complete liar. This shows that this really happened in the past. And I think that the jury cannot get a full picture of what happened on March 22nd and her communications with law enforcement without understanding that this is a reaction to trauma, and that is in fact her involuntary reaction and not another act. Now, if the state wasn't saying she was a liar, that would be different, but they have elicited that in testimony, given the inference that she's trying to be upset, she's trying to fake, and in the opening statement.
Right, but what would be the rule that would allow the defendant to introduce evidence to corroborate a prior event? And frankly, there has not been any testimony about that event yet by any other witnesses.
No.
But what?
Oh, I'm sorry.
But So, but what would be the rule that would allow the defense to introduce this evidence?
It's the rule of curative admissibility. We call it as lawyers all the time, opening the door. But the actual rule of opening the door is the rule of curative admissibility, which is that evidence that would not typically be admissible can be brought into court to cure because something else has come out in court that should not be brought in. And certainly Deputy Shields' opinion that she was trying to act upset or that she was somehow faking it is not appropriate, not admissible. Mr. Mangle has talked about her being a liar and having so many lies. That's not appropriate. That's not admissible. And under the rule of curative admissibility, this shows, because the state is calling her a liar, that this is an event and saying that her trauma is being faked, that this is an event. They have, in other words, opened the door to us being allowed to present this evidence to the court, and it is relevant. It is not hearsay. It's behavior that he actually observed, and it is simply the fact that she previously said, after being in an incident, that she went into a certain state, was disoriented, was asking about a horse, and said her name was Monica Carlin. And that her name has come up a lot, and it's been brought up by the state. The state's bringing in her birth certificate for some reason. The state has brought in evidence about her name change. The state is arguing that she's lying about her identity. She's lying about this trauma. And this is an involuntary response. And it's because the state has brought these inferences, we are allowed to do this because they've opened the door. Thank you. And if you would like me to find the case law on curative admissibility, I could. It would just take me a couple of minutes.
Well, I'm looking at, again, section 906.08, subsection 2, and specific instances of conduct of a witness. Now, Ms. McCandless is not a witness. And under 906.08 subsection 1B, she has not testified. But in any event, under subsection 2, specific instances of conduct for purpose of attacking or supporting the witness's character for truthfulness other than convictions is not admissible may not be proved by extrinsic evidence. And the court's belief is that this is extrinsic evidence for that purpose. And so that's why the court is sustaining the objection to going into that specific instance of conduct. Now, again,
Judge, could I be heard, please?
Yes, you may.
Okay, thank you. I don't. Judge, this isn't character evidence. When the court is referring to 90608, sub 2, that would be like, that would be something like, didn't you lie to Jason Mangle about you were going to meet him on Tuesday? And that's not really relevant to the case. It's not admitted but for the contradiction. That is the rule under 9060802. That is a rule of character evidence. This is not her character, though the state has tried to make it part of her character by claiming that she is a liar and a faker. This is not part of her character. The court has already ruled that this is admissible through an expert opinion, and that expert opinion is a medical diagnosis as to Ms. McCandless, and that medical diagnosis is one of kind of a combination of post-traumatic stress disorder with dissociative features, and I'm not intending to, I'm sorry, I'm trying to look for case law talk at the same time, and it's a little bit difficult.
Well,
And the diagnosis is a medical diagnosis. It is relevant to this case, so it's not extrinsic evidence on a collateral matter. And just to cite State versus Dunlap.
State versus what?
Dunlap, D-U-N-L-A-P, which is at 2002 with second 19, at paragraph 14.
so is that the with second site?
No, the with second site, Judge, is 250 with second 466.
456?
I'm sorry,
it's-
466, my mistake.
466, so it's,
250 with second, 466 is State v. Dunlap, D-U-N-L-A-P.
all right. Well, here's what the ruling is going to be with respect
Well,
to this.
can I cite the case, though, about curative admissibility? Or is the court,
Yes,
taking
because I will
granted-
read the case,
Okay.
but at this
all
point,
right, so,
but here's the court's ruling on this, is that at this point, that extrinsic evidence will not be allowed. If, in the event Ms. McCandless testifies, and if the state is challenging that particular incident as having not occurred while she testifies and is attacking her credibility with respect to that, challenging that, will reconsider, and you may be able to recall this witness. But I will read State versus Dunlap. But at this point in time, I'm not going to allow the extrinsic evidence regarding what Mr. Mangle observed following that
okay.
automobile mishap.
I understand the court's ruling. The very first paragraph in Dunlap, after the section that starts with Roman numeral 2, if you're using the open citation, it would be paragraph 14. So I was going to read the paragraph, but if you prefer that I not read that into the record because it's not going to be persuasive to you at this time, I won't do it.
Well, okay, and I will read that case. We'll get that
Okay.
case. And I trust my clerk has already let my judicial assistant know to get that case. So,
I'm sure, Judge. I just, we have the witness on the stand right now. That's why I had hoped to do it right now.
well,
because-
I understand, but at this point,
Okay.
again, we haven't decided that other issue, but I've given you a preliminary indication of what the ruling will be, and but we're not
Okay.
there yet.
Let me just get my bearings for a second before the jury
All right.
comes back
Judge,
in.
if I could just get a quick clarification on the length of that court's ruling. It's the potential for extrinsic evidence to be admitted later would be if the state specifically contested or tried to disprove in this case, the vehicle accident, not attack her credibility in general.
Yes.
Thank you.
Well,
Is that clear? In other words, if the state is, trying to present that never occurred, as far as that particular incident. Again, I've indicated that if Ms. McCandless testifies about that, and that's, again, you have an expert witness that you're calling, and if that's included in that witness's testimony, I will allow it in that context, but not extrinsic evidence having a trial on that particular previous incident.
we know that the state's not going to argue that the accident never occurred because we've provided them medical records of the actual accident. But the issue isn't whether they say the accident occurred. The issue is whether or not they are arguing that she is a liar and that she is faking when she's using the name Monica Carlin. That's what the issue is in terms of bringing this up. They are calling her a liar. They've already done it. They're going to do it when they cross-examine her, and that's why this becomes admissible under the doctrine of curative admissibility. They've already done it when it's not appropriate to have done it yet in this trial. In other words, attacks on her character, specific instances of conduct, reputation for lack of truthfulness should not even be in the record at this particular point in time.
Judge, and I know sorry, Attorney Vishny, I apologize.
That's okay, I know you mean well. The fact is that the state had, we even brought Mr. Mangle in here to tell him, or you've told him to not give opinions. I don't know if the state told him not to bring up specific acts of conduct regarding lying. I didn't ask him to give that answer. He decided to fill things in on his own. He's a prosecution witness. The defense did not open the door here, but the state argued this. However, I think I'm starting to repeat myself, and
Okay, well, here I just want to give you my view on this at this point in time. I don't think the state has taken the position that Ms. McCandless had not gone through a traumatic event, even in this occasion. And I haven't heard them or anybody say that she was lying when she gave the name Monica Carlin. And I think that's already been cleared up with that witness. He wasn't aware that she had again, that was previously her given name. The state, as I understand it, is basically pointing to specific things that she said and attempting to prove that those things are untruthful. But I think the state has not entered in any reputation evidence at this point as to truthfulness that I recall. And the statement by Mr. Mangle was on cross-examination. The state did not elicit that, and that, I understand, came out by accident. Mr. Mangle was responding to a question about whether he was thinking about getting back into a relationship with Ms. McCandless. So I just don't see the state having put in any evidence in general that attacking her character for truthfulness.
what about when Deputy Shields testified that he gave an opinion that he thought she was trying to be upset as opposed to being genuinely upset?
Well,
That is attacking her character.
there was a pretrial ruling. Deputy Shields was not to give his opinion about whether they were real tears or not real tears. He testified to his observation. But there are plenty of witnesses that have testified to her, and especially in cross-examination, to her being distraught and emotionally upset and so forth. So, in any event, that's the ruling at this point in time as it relates to the extrinsic evidence from this prior car mishap.
Okay.
And, but again, you made your record so far. I'll let you, augment that at a later time. Mr. Nelson?
Judge, I would like to be heard on that too, just briefly, just so the court knows before we bring the
I have
jury.
a question about experts, once this is all done, and how this relates to experts. So when it's all done, I just want to follow a question regarding that, Judge.
All right.
Okay.
Mr. Hahn?
Briefly, Judge, I don't want to go all the way through Dunlap, the case cited by defense, but the curative admissibility doctrine applies when inadmissible evidence is brought into testimony or into evidence. It's the state's position that the references discussed by defense are not inadmissible. Mr. Mangle can certainly testify about lies if it's based off of lies that he actually can show are, it's not his opinion. He didn't say she's a liar. He said there was always another lie, which is indicative of him having had a basis for that. And we didn't go further into tell us about those lies because I think that opens up an issue. But it was something that he was basing off of his experience, not an opinion about her testimony. So if she says this car is blue and he sees the car is red, he can say either she was wrong or she lied about it. There's a difference between that and saying somebody's a liar. So I think
Understood.
the inadmissible, the doctrine only applies if it's inadmissible. State's position is the evidence that's been brought in is not inadmissible, so the doctrine isn't invoked.
Okay. I would ask, so that we don't have a repeat of this, that when Mr. Mangle comes in before the jury comes in, that the court advise him that so we don't have a repeat incident, that he is not to say she lied to me or she told me this lie. Because, you know, just assuming no ill motives on his part, it is you're right, it's not opinion or reputation evidence, but it's a specific act of conduct that the state has not done a 90404 motion. And I'm not trying to infer that the state is trying to get Mr. Magel to say that, but perhaps if the court would advise him, that would be helpful.
All right. Well, again, and the state did not elicit that testimony. And so, and Mr. Mengel, again, he was offering an explanation that wasn't part of your question. It wasn't entirely responsive.
No, it was non-responsive.
Rather than answering the question, were you considering it, he gave his reasons why he wasn't leaning towards getting back into a relationship.
All right.
So, all right, well, let's bring Mr. Mengel back in.
That's fine. I'm going, while Mr.,
Well, we can take up the issue about expert at a later time.
I understand, but I didn't know if Your Honor, our experts are going to rely upon statements that Mr. Mengel has made to other people in police reports as a part of their opinion about this. I didn't know if Your Honor wants to do a voir dire of Mr. Mengel over lunch or at some other time outside of the presence of the jury. If the state's going to be claiming we need to get that fact into the record in order to have our experts testify. It's in the discovery, and so I just wanted to be clear, if that's something that the state is going to be requiring or objecting to, are our experts relying upon said fact? I would ask for the opportunity to do a voir dire outside of the presence of the jury so that we can have that. Again, it's already in the recordings and police reports, so I think it's an established fact that they can rely upon, but I'm just, at this point, for lack of a better term, paranoid. I just want to make sure that we're checking our boxes so that our experts can testify about that. Whenever Your Honor thinks we should take that up, we'll take it up then.
Okay, very well.
We can discuss that because I don't think it should be an issue.
Fair enough, thank you.
you wanted to.
I'm not, just wait just a second. I'm not entirely clear. Mr. Dufour, if you just clarify that.
Your Honor, experts can always rely on matters that are not part of the record. They can rely on things that are not admissible in evidence. But whether or not that information that they rely upon goes to the jury or not is up to the court to make a decision on. We don't have to have Mr. Mengel testify and voir dire that I said this or I said that. The expert can rely upon the reports, but that doesn't mean that they can tell the jury what they read in the reports.
All right, and I agree with that. Okay, let's bring Mr. Mengel in.
All right.